Second stage of 482 visa, the nomination. Hi everyone, I'm Josh from Australian Migration Lawyers and I handle all your skilled and work visas, especially the 482 visa. Now, if you're applying for a 482 visa, also known as a skills in demand visa, you probably realise by now this isn't just a one-click process. In our last video, we covered stage 1 of the 482, becoming an approved sponsor. If you haven't watched that yet, make sure to check it out first. But today, we're jumping into stage 2, the nomination, arguably one of the most important and misunderstood steps in the whole 482 process. This is the stage where most employers get tripped up, as one mistake can ruin your whole application. Let's make sure that doesn't happen to you. What is the nomination stage? So what exactly is the nomination? Let's say you're a business in Australia that wants to hire a foreign worker. This stage is where you formally tell the government, here's the position we need to fill, it's real, it's needed, and this is the exact person we want. It's like submitting a job offer with a legal spotlight on it. Now, you can't just nominate any role. The position must fall under one of 3 approved pathways under the SID visa. Specialist Skills Pathway. The first one is the Specialist Skills Pathway, and this is for high-paying, high-skill roles, usually white-collar jobs in tech, engineering, or healthcare. To qualify, the salary must meet the specialist skills threshold, which is currently set at $141,210 per year. Let's say you're hiring a senior data scientist or another high skill level role. This would be the right stream for it. Core Skills Pathway. Then we have our core skills that cover most standard skilled roles, including tradespeople, machinery operators, and technicians. This is the most commonly used stream. The minimum salary here is $76,515 per year, and the occupation must be listed on the core skills occupation list. For example, if you're hiring a qualified electrician or a diesel mechanic, this would be your pathway. The labour agreement stream. This one's for businesses with unique needs that don't neatly fit into the 2 categories above. Maybe you're in a regional area or have specific roles that are not listed on the occupation list. In that case, you could negotiate a labour agreement directly with the department or access an existing template agreement. But to apply in any one of these categories, you need to have an actual position available, and then you'd have to prove that it's genuine. Proving the job is real. This is where the government gets serious. They want to ensure that the role isn't just made up to bring someone into Australia. It is a requirement that these roles are assessed by a case officer as being genuine. For example, if a small cafe owner nominates a cousin from overseas as a business development manager on an $80,000 salary, but they're really doing admin and customer service, that's a red flag. Now, the case officer isn't there to judge your business decisions or salary offers. Their job is to verify whether the role is genuine. They'll compare your listed duties to the ANSCO description of the occupation and assess if the role fits your business. A sole trader operating as a tradesperson may have a difficult time nominating a full-time sales and marketing manager. They'll also look at whether you've employed Australians in similar roles before, whether your business is growing in a way that justifies new staff, and evidence like organisation charts, employment records, sales figures, or expansion plans. If you claim the role is vital to your growth, prove it with data, not just statements. How you advertise the position also matters. A transparent recruitment process with no qualified local applicants will help. If you have never advertised and suddenly nominate someone, that's suspicious. To prove the role's legitimacy, submit org charts showing how the role fits in. Also, submit descriptions of your goods and services and explain how the role will support your operations. If someone held the role previously, mention it. If you're scaling due to new contracts or demands, include that information too. They may also review your workforce makeup. A team made up of mostly overseas workers with a few locals raises concerns. But if most employees are Australian and this role fills a genuine skills gap, it will help your case. In short, if the role seems fake, mismatched to its title, or irrelevant to your business, your nomination could be denied. It is also important to show that you preference Australian workers where possible. And that's just one part. Things like work hours, job location, and employer obligations matter too. Hours, location, and the employer rule. The actual working conditions matter a lot. Things like how many hours the nominee will work, where they'll work, and who they'll work for. The nominated role must usually be full-time, meaning 38 hours per week. In some industries, This can vary between 32 and 45 hours if outlined in an award or enterprise agreement. Part-time roles are rarely accepted, and only in specific situations, like a specialist doctor working across rural clinics or a board member attending occasional meetings, will this arrangement be accepted. But for the vast majority of applicants, full-time work is expected. Under condition 8607, 482 visa holders must only work for their sponsoring employer or an associated entity. That means no freelancing or side gigs. Previously, if you left your sponsor, you had 90 days to find a new one. But from July 2024, that's been extended. Now, visa holders have up to 180 days at a time or 365 days total over their visa period to secure a new sponsor. During that time, you're allowed to work for any employer, but it would be best for you to continue to work towards finding a new sponsor to nominate you for your original occupation. Some occupations have certain exemptions, which will allow them to work for different employers in some circumstances. We'll show the full exempt list on the screen. Make sure to pause and screenshot it, as these details can change. Now let's talk money, because when it comes to the 482 nomination stage, salary is a big deal. Salary requirements. The Australian government is clear: sponsoring overseas workers should never be a way to cut costs or underpay. If you're not offering a fair wage or can't prove it, your nomination can be rejected immediately. For example, if you're hiring someone through the specialist skills pathway and offer $120,000, that might sound competitive, but the threshold for that stream is $141,210. Even if both sides agree and it's above the market average, it doesn't matter. The nomination will fail. Similarly, under the core skills pathway, hiring a trades worker like a welder or a chef requires a salary of at least $76,515. Anything less won't be accepted. But meeting the threshold isn't enough. You must also show that the wage matches the annual market salary rate, what an Australian would earn for the same job in the same location on a full-time basis. You'll need evidence that the offered salary aligns with what others in that role earn, either through contracts and payslips for an existing staff member or by showing market data. If no one in your company holds that role, you'll need external proof. Recent job ads, salary surveys from trusted sources, or written advice from a union or industry groups will meet this requirement. The salary must include guaranteed wages or benefits, but not reimbursements, superannuation, or unpredictable extras like profit sharing or gifts. If you're relying on an award or enterprise agreement, you must submit a registered copy from the Fair Work Commission that clearly shows the salary bracket for that role. In short, you need three things: prove the stream-specific salary threshold, prove that it aligns with market rates, and back it up with hard evidence. Miss any of these and your nomination will be at risk. And even if you get all that right, many applications will still fail at the next stage. Labour market testing. Labour market testing means you must prove that you made a genuine effort to hire an Australian worker before nominating a foreign worker. That involves placing a proper job ad, not informal posts on social media, but listings on platforms with national reach, such as Seek, Indeed, or Jora. Major newspapers or national radio may also be used, provided they reach a broad Australian audience. However, it's difficult to prove that. You're required to run at least 2 advertisements in English, and they must be live for a full 28 consecutive days. These ads need to either overlap or run continuously across that 4-week period. Each ad must include very specific details: the job title, clear job description, the skills required, the name of the employer or agency, and the offered salary. It must also specify that it's a full-time role. Missing even one of these elements makes the ad invalid. For example, if you run a 4-week ad on Seek but forget to mention the salary, your labour market testing will be considered unsuccessful. You can post the ad through a recruitment agency or a third party, but only if they're authorised to do so and everything is properly documented. The sponsor doesn't need to post the ad personally, but the responsibility to get it right still lies with the business. The core goal here is to convince the case officer that there are no suitably qualified Australians available for the role. That's why where you post, how long it runs, and what you include in the ad all matter. There are exemptions, of course. If the nominee is from a country that has a free trade agreement with Australia, such as the UK or the US, LMT might not be required. These exemptions are based on trade obligations under these agreements and the World Trade Organization's General Agreement on Trade in Services. But don't assume you qualify for an exemption. If you skip LMT or do it incorrectly when it's required, your nomination will be refused without hesitation. So let's say your nomination is approved, your 482 visa is granted, and you've landed the job in Australia. The next question is, what comes next? Processing priorities and rough cost estimates. Once your nomination is submitted, you might assume it's just a matter of waiting in line, but that's not exactly how it works. The government processes skilled visa applications based on priority tiers, and if you understand this properly, you can actually fast-track your outcome. Here's some good news. The 482 is on the government's priority processing list, which means it's taken very seriously. At the top of the priority list are employer-sponsored visas lodged for roles in designated regional areas. So if your job is based outside major metro hubs like Sydney or Melbourne, your file could jump the queue. The government has a full list of regional postcodes available on the Home Affairs website, and we'll put that link on the screen. Feel free to screen record or screenshot it. Right after regional employer-sponsored applications, the second highest priority is given to jobs in healthcare and teaching. So let's say you're a regional hospital sponsoring a GP or a school hiring maths teacher, your application will fly through the system faster than most. Third in line are nominations made by approved sponsors with accredited status. These are trusted, high-volume employers with a strong compliance record. If you're one of them, your applications are streamlined and pre-cleared through priority channels. Everyone else follows after, and while those applications still move, they'll typically face longer wait times. And if you're wondering how much this whole process might cost you, head over to the AML fee calculator on our website. It breaks down your likely expenses based on the visa stream, the number of applicants, and the sponsorship structure. It's free to use and it helps you plan ahead before you make a commitment. If you've made it this far, you're already ahead of most applicants. But remember, getting the nomination right is often what makes or breaks your visa. Have you got questions about the process? Drop them in the comments or visit our website to speak directly with a migration lawyer.